Disputes, co-organized by the Chartered Institute of Arbitrators East Asia Branch Young Members Group, or YMG for short, and HKIAC. I'm Ronald, the current chair of the YMG, and I'm honored to be welcoming everyone to this event on behalf of YMG. It's nice to see that we're now having in-person events. I look forward to the near future where we can have events at full capacity, in person, and maybe without face masks. Of course, I'm also very pleased to see that so many participants joining us all over from the globe, all the way from Afghanistan to New Zealand, from Canada to the Bahamas, and from France, and all the way to Japan. It is impressive how quickly we have adapted to the new normal. Today's discussion will revolve around the intellectual property arbitration disputes. Since the introduction of the Arbitration Ordinance in Hong Kong, Hong Kong has been firmly entrenched in the upper echelon of arbitration hubs around the globe. To keep abreast of the fast-moving field of arbitration, Hong Kong passed a bill to amend the ordinance in 2016, which came into force in 2018, which clarified that disputes over intellectual property rights, or IPRs, may be resolved by arbitration, and that it is not contrary to public policy to enforce arbitral awards involving only IPRs. In essence, Hong Kong now recognizes and allows for disputes in respect to IPRs to be arbitrated, and the Hong Kong courts will generally enforce arbitral awards, even if they solely relate to IPRs. 2021 marks the 5-year anniversary since the introduction of the amendments and HKIAC's launch of its panel of arbitrators of intellectual property. We have invited a group of heavyweights in the field of IP arbitration to discuss this topic. Now to introduce them in order as they appear on the flyer, Ms. Winnie Tam, Senior Counsel, Head of the IP Committee of the Hong Kong Bar Association and International Arbitrator, Ms. Xiaojun Wang, Counsel in HKIAC's arbitration team, Mr. Matthew Light, Partner and Head of the IP Asia Pacific at Bird & Bird. Finally, we have our moderator, Mr. Sebastian Hughes, Arbitrator and Barrister of the Hong Kong Bar, practicing out of Prince's Chambers. Before passing the mic to our moderator, I would like to take a moment to thank everyone who helped organize this event, including the team at HKIAC, led by Mr. Kevin Chow, the Marketing and Events Coordinator at HKIAC. I would also like to thank YMG's organizing committee for this event, led by Mr. Edward Chen and Mr. Richard Poon. And I also like to thank specifically Mr. Sebastian Hughes for spearheading this event. Now to you, Sebastian.
Thank you very much, Ron.
Good afternoon, and thank you for Ronald and Mr. Sebastian Hughes for your kind introduction. It is my pleasure today to share with you all on HKIAC's experience handling intellectual property arbitration. As said, 2021 marks the 3rd year after the amendments to the Arbitration Ordinance that any disputes concerning IP rights may be submitted to arbitration in Hong Kong. It is also the 5th year upon HKIAC's launch of the Panel of Arbitrators for intellectual property disputes. So first, I'm going to use the next 5 minutes to briefly conduct a review of HKIAC's cases in relation to IP disputes in the past 5 years. So from 2016 to 2021, we had a total of 38 IP arbitrations administered by HKIAC. That is about 4.3% of all cases administered by HKIAC. As you can see from this slide, we had the largest IP caseload in 2017, being 11 cases that year. For the rest of the years, we usually have around 5 IP cases per year. I should mention first how HKIAC characterizes an arbitration as an IP dispute. So usually we will only say a case is an IP dispute if the underlying contract is obviously related to intellectual property rights. A typical example would be a dispute arising out of a licensing agreement. I know that we do also have some other arbitrations in which IP right is an important element. For example, shareholder disputes in relation to joint venture agreement, and the IP dispute is an important element in the merger and acquisition. However, these cases are not counted as IP disputes for this session. Next slide. Well, this relates to my next slide, which shows the distribution of different categories of claims across 2016 to 2021. So I know generally within the IP field, disputes are usually divided into 4 categories. We have licensing disputes, infringement disputes, ownership disputes, and validity disputes. So in HKIAC, we rarely encounter ownership or validity disputes. Most of our cases are licensing and or infringement disputes. And among these, I have to say a large chunk of our cases relates to respondents' non-payment of licensing fees. It probably goes without saying that these cases are usually straightforward. They typically do not involve complicated technology issues or legal arguments. From 2016 to 2021, there are a total of 17 cases of this nature. Approximately 45% of all IP arbitrations at HKIAC. Apart from these easy disputes, the other half of our caseload are real licensing or infringement disputes. Most of the cases have both licensing and infringement elements. A typical one would be something like this. Say claimant and respondent signs a licensing agreement, and respondent goes and misappropriate the licensed IP right, either for the purpose not allowed in the contract, or respondent just will not stop using the technology after the agreement expires or terminates. Therefore, the claimant brings an arbitration. These claims sometimes come in the form of a breach of contract claim, sometimes as an infringement claim. You also see from the chart that although we still have some dispute over licensing fees, the percentage of these easy disputes has been decreasing steadily. Complex IP disputes are taking up more and more of our caseload over the years. This brings me to our next slide, which shows the shift of industrial sectors in the past 5 years. So from 2016 to 2019, IP arbitrations have a focus in manufacturing and entertainment sectors. So when we talk about manufacturing disputes, we are generally referring to manufacturing of garments, electronic components. And for entertainment sector, we typically see format licensing of TV shows, disputes relating to telecast of sports games, or games and movie copyrights. These are considered like low added value industries. However, from 2019 to 2021, we are seeing more and more disputes in the technology sector, including computer software, pharmaceutical, and telecommunication. Reading this into conjunction with the previous chart in relation to category of disputes, this to some extent reflects the radical structural change of like mainland China's industry in the past 5 years. Next slide, thank you. And about parties' nationalities, our top 5 users come from mainland China, United States, Hong Kong, Cayman Islands, and South Korea. I have checked our case file, and unfortunately, mainland China do continue to be the #1 nationality for respondents in IP disputes. Okay, that summarizes my overview of Hkc Statistics in relation to IP arbitration in the past 5 years. My next 2 slides relate to HKIAC's IP panel and intermeasure in IP arbitration. I will save those for Sebastian's questions later then. Thank you.
Thank you very much, Wang Xiaojun. I'd like to open up some panel discussion by asking a general question about arbitration and IP. And perhaps if I could ask Winnie to start first, and then I'll ask Matthew and Xiaojun to give their perspective as well. So this is the general question I'd like to pose for the panel. Given that arbitration requires agreement, and given that most intellectual property disputes involve a right owner and an infringer, what is the role of arbitration in IP disputes? Because, of course, usually you can't get an infringer to agree to resolve the dispute through arbitration. Winnie.
Thank you very much, Sebastian, and thank you very much, Xiaojun. for sharing the statistics. In fact, that brings me to an answer to Sebastian's question. Now, of course, I mean, arbitration is not the best dispute resolution method for the ordinary infringement case of IP rights, because a lot of the times you have a kind of David and Goliath situation where a smaller infringer, a smaller sized business is being sued for infringement of an owner's rights. Now, that doesn't lend itself to arbitration because arbitration is a consensual procedure and each party will have to be willing to put up the funds for conducting the arbitration. Now, so in my experience, most of the IP-related arbitrations spring from contract. And normally it is very much innocuous in the sense that it doesn't even look like an IP dispute in the first round of pleadings. So you receive a notice of arbitration and it's maybe a distribution agreement or an OEM manufacturing agreement. At that point of time, it doesn't even look like an IP dispute until the defense raises matters which are core IP issues. Now, and Xiaojun's statistics brings me to the point. How should an arbitral institution categorize these cases? And why is it important to categorize them properly? Because you need to find, because the parties expect you to find the right arbitrator, if it is sole arbitrator situation, or if the president of the tribunal will have to be appointed by the arbitral institution, then the parties will expect the arbitral institution of recognizing the fact that there are IP issues to be resolved in the case. Now, how do the IP issues arise? For example, in an OEM manufacturing agreement, say for photocopiers, the owner of the rights may also make cartridges, but they didn't ask this particular maker to make the cartridges. However, there is this alleged breach by the rights owner, the alleged breach of rights for failing to provide technical support, leading to loss on the part of the OEM manufacturer. And this is an ordinary contractual dispute arising out of an OEM manufacturing agreement. However, when the respondent's manufacturer comes back, they say they would make all sorts of allegations. For example, it may be said that there was breach on the part of the claimant by copying its engineering design or copying somebody else's engineering design, leading to their loss. And sometimes, I mean, these issues arise only in the second batch of pleadings, and the case evolves into one with a mixture of contractual disputes and IP disputes or IP issues. Now, of course, no one arbitrator would claim, say, I'm an expert in contracts, because all of us are expected to be experts in contracts in commercial arbitration. So everybody can be expected to arbitrate commercial contract disputes. However, if the IP issues are not properly handled and spotted for a start, and handled, and the proper law applied in the course of the arbitration, then that could lead to huge dissatisfaction from the parties. And that is why I believe a proper categorization is very important. Now, the role of IP arbitration, as I see it, will be more in this type of situation than in the ordinary, in the sort of a traditional type of rights owner suing someone for infringement of trademarks or patents and so on. Because unless the infringer is actually in contract with the rights owner, that simply doesn't happen. Unless you have I have experienced one case in which the parties were in litigation all over the world, and it came to a point when they decided to settle their litigations all over the world, and decided that if any disputes arises out of the settlement agreement, then the matter goes to arbitration. It is only in that sort of situation where you have a kind of consensual arbitration arising out of infringement claims. So that's what I would like to express for now. Thanks.
Okay, thank you. Yes, when I first heard of the idea of arbitrating an IP dispute many years ago, I thought this is crazy, because most of the time I'll send a cease and desist letter and getting the target to even respond was a big task, let alone to agree to arbitrate the dispute. So at first I couldn't see how it played any role at all. However, in the last 15 years, a lot of my work has revolved around quite a niche area of standard essential patent litigation. And these are global disputes involving usually a lot of national patent rights. And actually, arbitration has emerged as a very useful tool for settling these sorts of disputes. So it is in public record, it's public. There are a number of companies that have used arbitration. Nokia, LG, Samsung, Ericsson, and Huawei even have, over the years, used arbitration as a means to resolve these SEP disputes. I think I've got a bit of time, so I'd like to explain a little bit about what I mean by an SEP dispute, because from that you then can see how arbitration is indeed a useful tool for resolving the disputes. SEPs, standard essential patents, are to do with standards. Standards are basically a set of specifications which explain and dictate how things work. And if you think specifically about a mobile phone, the reason that I can use my Apple mobile phone and talk to someone that has got a Samsung mobile phone is because of standards. People have agreed that these two rival companies will operate their mobile phone in a way that they can talk to one another. Same goes for the reason why I can use my phone when I travel overseas, when we used to be able to, because countries around the world have agreed to follow the very same standards in the technology and how the devices work together. Standards are set by industry. They're done under the sort of auspices of standard setting organizations. And the way it works is that all these rival companies come together with their technology, their R&D, and say, I've got a good idea. Winnie says, I've got a good idea. We argue it out and we decide which one of our ideas is going to be the standard going forward. After a lot of discussion, the standard's frozen and that's it. That everyone must then comply with the standard in the products that they produce. In that process, we've come to the table with our own clever ideas, our inventions, our patents, and you get to a point where a standard is set and any manufacturer must use that standard and therefore must use the patents that we have all brought to the table. You cannot make a mobile phone without using other people's patents. In a phone, there's thousands of patented technologies in a mobile phone, owned by dozens and dozens of different proprietors. So you end up with a situation where Apple, in my example here, needs licenses from a lot of different people in order to make the mobile phone. This is where the dispute arises. The argument is over money. How much should Apple pay? And I'm not picking on Apple particularly, other than that I happen to have an Apple device. How much should Apple pay to all the different patent owners around the world? This is essentially a global dispute about national patent rights, because patents are national. And typically over the years, this sort of dispute has been really characterized by multi-jurisdictional patent litigation. You'll have litigation in half a dozen different countries between the same two companies, often over the same patents, but because patents are national rights, they have to be litigated in the local courts. This is what the smartphone wars have been all about over the years. And I think years back, everyone was familiar with Apple and Samsung fighting each other. And that was all to do with standard essential patents. Arbitration is a way of bringing the parties out of the courts and having one forum decide the issues in dispute, normally the money involved. And that way you avoid having to go to all the different courts and have litigation taking place. And that's what I've been involved in over the last several years. And that's how I came to realize that, in fact, arbitration does have a role in IP disputes.
Yes. Thank you very much, Matthew. Indeed, standard essential patents is a very hot topic in arbitration in general, and particularly within the IP circles, in the patent circles. Now, in my experience, in fact, IP issues do arise in the context of international sale and supply agreements, and quite often as well, because you have a situation where you have a dispute, say one party's refusing to pay, and then the other party accusing the other party of copying or reverse engineering the design that has been supplied and doing its own business on the side. And that is a very typical kind of a dispute which could arise in distribution agreements. At the moment, because the arbitrability of IP disputes are not entirely clear in some countries, although as a result of 2018 amendment to the Arbitrations Ordinance, it has now become clear in Hong Kong. International arbitrators or arbitral institutions are not attuned sometimes to the fact that these are IP disputes which require expertise of those with knowledge and experience in resolving IP disputes, whether in court or otherwise, to actually look at it and apply the law correctly. And they are all treated as commercial disputes to be resolved by any commercial arbitrator. Now sometimes the result is correct and nobody disputes it. But other times it could lead to very different results. My own experience is that because I started arbitrating about 5 years ago, and as an IP specialist first, and then I was given commercial arbitrations to do as a result of, say, other arbitrators nominating me. I have found out that when I come across IP disputes, IP issues within the dispute, my idea was very different from the other arbitrators' ideas, other arbitrators who are only doing commercial arbitration and have no IP experience. And maybe that was the reason why they thought, oh, better have someone who understands these issues. So I started to have IP to have arbitration cases because of that. And in that process, I realized that if I were not there to help with the case, then the result could have been different. Now, I'm not trying to lay any blame on arbitral institutions, because sometimes when they get to a point when they have to constitute the tribunal, they would not know that there are IP issues, because it only surfaces at a later stage when the pleadings are complete. And that is something which we all have to bear in mind, because sometimes all of these are sort of swept away as commercial, ordinary commercial disputes, as a result of which a lot of commercial arbitrators, although they have no basic IP knowledge at all, they claim to have arbitrated intellectual property. All of them do. I mean, there are a few who would actually put up their hands to say, I don't do IP. They all say they do IP. And indeed they have, because they have come across these issues in IP, like licensing disputes for shortage in license fees and so on. And those are regarded in their eyes as IP disputes, as arbitral institutions regard them as IP disputes. But they are not really arbitrations with IP issues to be resolved as part of the award. And I think that distinction is quite important. And I was quite surprised to see the figures of Xiaojun, because 2017, you saw a lot of IP cases on the bar chart. And then after 2018, after the amendment of the law came into effect, there was a drop. I don't know whether it was classification or anything, but I think if that is indeed, just what happened, then there should be added efforts of the HKIAC to advertise the fact that, yes, we recognize, we do IP arbitrations, and we treat IP issues arising in commercial arbitrations as arbitrations, and will pick the right arbitrator accordingly. We have, as a result of the amendment of the Arbitrations Ordinance, the HKIAC quickly built up an IP panel of arbitrators. But very few arbitrations go to anybody from the panel. Very few. I mean, sometimes not because they're from the panel that they were picked. But that is something which which we need to look into, because good arbitrators need nurturing. They need to be given opportunities. If you relegate, oh, these are just IP experts, they don't normally do arbitration, then they will never get a chance to do arbitrations. Not many have the good luck that I have in doing quite a lot of commercial arbitration, although I was otherwise recognized as an IP expert. So we need to, the arbitral institution needs to build up the IP panel and recognize them as being as good as the commercial arbitrator in arbitrating normal mixed disputes. Thank you very much.
Perhaps if I could add something on that point, I think Winnie makes the fair and valid point that from the perspective of the centre, it's often not at all clear that an IP issue may arise. But using the example of, for example, a manufacturing delivery contract, if it arises at the time of filing of the defence and perhaps counterclaim that there are issues of copying, infringement, validity being raised, I guess one thing that may then come into play is actually the arbitrator's duties to the process, and the arbitrators may need to stop and consider whether or not they're able to fulfil their duties if these specific infringement and validity issues arise.
Well, sometimes it is difficult to spot the issue because the word infringement does not even feature. Because sometimes in a contractual context, it only says, well, the counterclaim will, there's a defense and counterclaim filed, and the defense and counterclaim says, but the claimant copied XYZ, right? Copied my design or something, right? Or made something which is same or similar. That there's no infringement as a word popping out of the pleadings. And hence, this may get lost. But at the core, the test in deciding, okay, did he do that? Did he copy? Was then what he produced on the site same or similar? Now, in this same or similar or copying test, the IP lawyers will know that some things are taken into account, others are not. Now, what sort of standard do you apply? You have to look at it from an IP angle, or you may have to look at it from an IP angle. Because the contract, sometimes they even contain clauses to say you must not reverse engineering my design, and so on. And those give rise to IP issues when that clause is relied on as a ground for breach of the agreement. And that is better handled by people who understand those issues, in my view.
Thank you, Winnie. Perhaps if I could move on to ask the panel a question, which I think flows from Matthew's discussion earlier. Perhaps if Matthew could answer it first. And the question is this: what do you see as the benefits of arbitrating IP disputes compared with the traditional route of litigation in the courts? And perhaps focusing on your experience with multi-jurisdictional patent disputes, please could you discuss the pros and cons of both approaches?
Yeah. Okay, yeah, thanks. And keeping it sort of specific to what I was speaking about earlier in the area I've been practicing in for the last several years, one of the key aspects of arbitration is confidentiality. And in these SEP disputes, it's always about the money. And in order to work out how much party A should be paying to party B, you need to dig into a lot of highly sensitive confidential commercial information. One of the ways of valuing a portfolio of patents and what the license fee should be is to look at comparable licenses. So what has the patent owner licensed the portfolio out to other parties at in the past? What rate has been charged in the past? The rates are highly confidential. Ordinarily, the patent owner will not want to disclose that, certainly not in open court. Often will not really want to disclose it to the other party directly, only the outside counsel and so on. Under an arbitration, it's much easier to keep things confidential. It's kept completely out of the public eye. There are several judgments that come down, many judgments is the correct word actually, where the court has carefully redacted all the the information about the parties in the comparable licenses and the rates, but it doesn't take much to really work out who they are and what the rates are likely to have been. And so whilst the court may think it's properly redacted everything, it still becomes public. So the confidentiality aspect of arbitration is very attractive in the SEP field. Another very attractive part of it is cost. The cost of a multi-jurisdictional SEP dispute between two major players, you could easily spend, $50 million in a campaign. I mean, it can be that high. If you can condense that all into one arbitration, which will still be costly because it will be a big process and so on, you've still saved a lot of money on both sides, and that's attractive. There are others, but maybe I should let other people chip in as well.
I think I totally agree. I'm confident. Sometimes we have to set up confidentiality clubs within the arbitration to allow experts and counsel and the parties limited access to the confidential information. And in a court context, this could be difficult, and courts are not normally amenable to too high a degree of confidentiality, particularly in terms of the judgment to be rendered. So that is a very important feature. Now, it has been said that arbitration saves costs, and there also another camp which says that arbitration is actually much more expensive than court proceedings. Well, I think that arbitration is sometimes expensive, but it is a very efficient way of resolving dispute because the procedure is tailored for the parties, and you don't have to line up in a long queue in the court diaries to get your case heard. Now that we have an IP list, things are slightly improving, but the IP list, I heard from the IP judge, is very, very heavy, and a trial date is not available until at least, if you're talking about this moment, at least 2023. And so it is not easy to get a resolution of the an IP dispute in the court, whereas in arbitration, you can always apply to have a quicker procedure, and you try to argue for a limitation of the periods for each step, and press the arbitral tribunal for an early hearing.
Thank you.
Sorry, just one more point. Of course, there is this choice of arbitrators point. You can choose the person who knows about the technology that is under dispute, be it biochemistry or computer science, and that is not available in the courts.
That's precisely the point I was going to make. Of course, many jurisdictions like Hong Kong, Singapore do have IP lists and do have specialist IP judges, but it's probably fair to say they're more likely to be generalists. And to use the example of the patent litigation that Matthew gets involved with, it may be that the parties would be happier to consider appointing a 3-member panel of world-renowned experts in that particular field. And it's perhaps much more likely to be able to do that using the arbitration process than litigation.
Yeah, very, very much so. It would always be a 3-person panel, and that's part of persuading the counterparty to accept arbitration. You get to pick one, I'll pick one, and then together. We should talk about some downsides of arbitration as well, and there are a few. In this area I work in, one of them is actually getting parties to agree to it. So I did reel off some names earlier of SEP owners who have used arbitration, but looking back over the last decade, there's been much more litigation than arbitration of the royalty rates. I know some of it may never have come to light, but you do tend to get a feel for who is using arbitration, and it is not as prevalent as you might expect. 2 other downsides. Experience shows there's a tendency of the panel to split the difference, go for the middle ground. When the dispute is solely about money, just splitting the difference isn't necessarily the right answer. At least with the court, there's a greater likelihood that the judge will come to a decision that he or she thinks is the correct outcome. And the other thing is when they get it wrong in arbitration and there's no appeal, and that does happen. I've seen that as well, where the award was actually probably lower than it should have been, and there's no appeal process that you can go through. And it does have a little bit of a ramification in that one low award then gets used as a sort of comparable number or comparable license for the next dispute. So it's not just the one case that you've ended up messing up with the wrong answer.
On the downside of arbitration, cost is often cited as a downside, because normally you have a huge team of lawyers, and then arbitrators could be coming from 3 different jurisdictions, and you have to fly them in and put them up. But I think going forward, there will be a lot more virtual hearings than before. And I truly think that even the international arbitrators who are used to jet-setting about, they are quite enjoying not having to always travel as a norm rather than an exception. And I can expect that parties in order to save costs may actually prefer some degree of virtual hearing. And it has been experimented in the past 2 years or 1 year at least, and it has been quite successful. And people are getting a hang of it, and even the counsel doing cross-examination do not feel handicapped with the witness being remotely interacting with him. So I can see more of that coming to solve this issue of cost. Parties' agreement sometimes is very, very difficult to get, even in the course of the arbitration. Even on the slightest procedural issues, parties may argue tooth and nail. I remember I had to attend a hearing in London for 2 days in order to sort out the terms of a confidentiality club. Now, that is rather ridiculous. It was hugely expensive, but the parties were it was a very contentious matter, and that was how it happened. But in the future, I can see that these things can be dealt with in a virtual hearing, which will mean much more savings. Thank you.
Yeah, speaking of cons of arbitration of IP dispute, I'm not sure whether this is really a disadvantage, but an arbitral award is only binding upon the parties to the arbitration, and there is confidentiality issues. So once a licensor obtains a successful award against the licensee, there is an issue whether if it's the court proceeding, maybe like the same contract, you can sort of argue that the award or the decision can apply universally to all licensing agreements. However, in arbitrations, that might be an issue. Yeah, and I would also like to share some of our Hkc statistics on the appointment of IP panel members. May I have the slides pulled out? I know this, we should have promoted this panel seemed to be of the opinion that we should appoint more IP specialists in our arbitrations. Just some statistics about previous cases. So we do have an IP panel specialist, as has been said. We have maintained a very diverse profile. We have 51 members at the moment. They are admitted in 14 jurisdictions. They can speak like a total of 19 languages. That's a very diverse and I would say an impressive profile of our IP panel. As said, we had 38 IP cases, and in these cases, there were a total of 68 appointments or confirmations of arbitrators in general. And 23 of these appointments and confirmations come from actually the IP panel. we will, like HKIAC, as a member of the Secretariat, I obviously I bear in mind, I try to identify what is in dispute when we make the appointment. And however, I think like that I wouldn't say that is not sufficient. I think we do appoint IP panel members all the time. And actually today on this panel, there are two members that are already, like Winnie and Sebastian, they are already on our IP panel. And I would expect to also join our panel.
I started the application process and then put it.
Yeah, that's all from me. Thank you.
May I supplement one? Thank you very much, Xiaojun. I'm sure that with all these, all the IP cases, all categorized as IP cases identified in the statistics, the IAC will actually draw from the IP panel. But I think going forward, we may consider properly categorizing mixed cases like, contract and IP, and take a different view of those cases where we can or where we have sufficient information, and then to draw more often from the IP panel. Thank you very much.
Well, I'm pleased to say that we're getting some very interesting questions from those of you who have joined online, and they overlap with some of the issues that we were hoping to discuss. So I think it might be useful for me to launch into some of these questions. The first deals with injunctions and interim relief, and the second one deals with arbitration relating to validity of IPR, which we've already touched upon. But perhaps to start with the question on injunctions, this comes from Stephen Burt, and Stephen's question is, arbitral tribunals can issue injunctions pending determination of disputes, including to maintain or restore the status quo and preserve assets and evidence. Breach of a court injunction is contempt of court and serious. But what are the consequences of ignoring an arbitral injunction, and how can it be enforced?
The awarding the injunction itself is enforceable in the courts. If the party decide for various reasons not to enforce it right away, and there is evidence of breach, this is something which obviously can be taken into account in the award. Yes, I mean for injunctions, we also rely on the courts to enforce it.
Yeah, nothing to add really.
Okay. We have a question on validity, and these issues have already been addressed, but this question comes from James Dingra. Two questions, in fact. Referring interestingly to an article to do with arbitration of IP validity disputes, which apparently cites the Hong Kong Arbitration Agreement and similar legislation in Singapore. The question from JMs is, in the panel's view, what can make a third-party infringer agree to opt for arbitration instead of litigation in various national courts? And the second question is, I think something that Wang Xiaojun perhaps mentioned earlier, the award is only enforceable against the infringer if he loses the case, but not against other infringers, as in the case of court litigation. Is that the case, and what are the issues arising there?
Maybe I'll help answer the first question. As I said, it is always difficult for a small infringer to be persuaded to arbitrate. Now, sometimes from a sort of litigation position where you have rights owners suing the infringer, once the litigation has started, what do you do? Now, there is a thing called mediation, of course, and I have seen cases where parties are persuaded to come to the table to mediate. In fact, the judge will put certain amount of pressure to make sure that the parties attempt mediation. I mean, in the Hong Kong rules of courts. And then in the course of mediation, if the parties could come to some agreement that if they fail in mediation, they go for arbitration, then arbitration can happen. And I have seen such an agreement before, although it didn't actually become an arbitration in the end. Alternatively, you may, well, actually, there are no alternatives. Because if I were a very small infringer, I would never agree to arbitrate. Why should I? You can sue me, and then I may or may not pay the damages that the court makes me pay, but I'm just going to play dead. The small infringers tend to do that, and they will never be persuaded to arbitrate because then they have to sort of pay money up front and all that.
And I think also some of the big infringers will agree to arbitrate. So in this scenario of multi-jurisdictional litigation, it makes absolute common sense to say both sides, let's stop litigating in the courts around the world, let's go to one forum and sort it out. It'll save both sides a lot of money. That's good common sense and logical, but it's not necessarily good tactics because you are putting all your eggs in one basket. Both sides are then. And if I'm an infringer or a defendant in these SEP litigations, and I've got the funds to be able to fight across countries, and given that the license fees could end up being in the billions of dollars, it actually makes sense to spend quite a lot of money litigating around the world. So there isn't a magic answer. Sometimes it's just when a situation arises on the fact that for both parties it makes most sense to call it a day and settle. Sometimes I've seen that happen where an implementer, a manufacturer of mobile phones, has got battles going on with several different SEP owners at the same time. And just their internal resources and their litigation funds are stretched to the point that it's better to settle some cases, put others to arbitration, and then leave maybe one or two for the big fight. So no magic answer.
One of the things that was discussed when arbitration of IP disputes was being discussed and implemented was the fact that it's national registries that deal with patent rights, trademark rights, design rights. So in terms of the interplay between the private confidential arbitration process and the patent and trademark registries, taking the hypothetical of Matthew's case where there are ongoing patent infringement actions or indeed validity actions in several jurisdictions, if it's agreed to set up an arbitration and the panel, by the parties' agreement, reaches a definitive conclusion on validity of an IP right, practically speaking, how would the parties go about arranging for the registries to implement that award? Well,
the only way would be the arbitral panel issues an order that the proprietor must withdraw their IP right, cancel the IP right. The panel can't order that it be removed from the register or anything of that nature. So it's more a direction to the party to do it.
But only if the parties so agree. So I can completely envisage a situation where a licensee's counterclaims for invalidity, and the arbitral tribunal is then to decide on the question of validity or invalidity. And then if it is to be decided against the rights owner, then because of the arrangement, it is only to bind the two parties. So there could be a situation where other licensees will continue to pay license fees under the impression that it is still a valid right, whereas that particular licensee, by agreement to arbitrate on certain terms, that licensee, of course, does not have to pay license fee. So that is really a matter of arrangement between the parties, isn't it?
Yeah, absolutely. And it's not dissimilar to a situation that does arise in litigation where a defendant has proven or is getting to the point of proving the patent is invalid or the other IP right is invalid. the parties settle, they have a confidential settlement agreement.
Yeah.
And part of that usually is that the defendant will keep quiet about the validity issues.
Yeah.
And the patentee then continues on in life with its patent on the register. So it's a similar sort of situation.
There's an interesting point arising here, and that is in the course of my work in the working party on the amendment of the Arbitrations Ordinance in respect of arbitrability of IP, we came across American legislation where it says that if you have an adjudication by a tribunal, you must the registrar of patents must be notified of it. All right, and which means that it destroys the kind of only binds the parties thing. It would then result in the invalidation of patent in the registry. Now. And then I asked for inquiry to be pursued as to how the practice was. I mean, that's a U.S. law, but how was it in practice? And the answer came back saying that nobody ever tells the registry. And then the impact was that the Hong Kong legislation did not adopt that particular provision. So that's how it stands right now. There's no obligation to inform the registry.
Forgive me for going back to the question of urgent relief. There was a question related to that I wanted to ask Wang Xiaojun and Winnie. So the question is, how quickly can parties obtain urgent relief in IP disputes, whether using the arbitration process or using the courts?
Thank you. Maybe I can start with some Hkc statistics again. So among the almost 40 cases that we received, we have seen one application for intermeasure order to the tribunal and 2 emergency arbitrator procedures. And there's a third tool in which, like the Hong Kong PRC intermeasure arrangement, we haven't seen any applications in that respect, but we do look forward to. Just a brief introduction of this is really some very specific HKIAC arbitration tool. So under the 2019 HKIAC administered arbitration rules, there are 3 tools for a party to make an intermeasure application. So before the constitution of the tribunal, the applicant can actually apply to appoint an emergency arbitrator and request the emergency arbitrator to order interim relief. We had 2 cases among the 40 cases that I mentioned, and both emergency arbitrator dismissed the applicant's application. So under the HKIAC rules, once the emergency arbitrator receives the case file, that person has to issue his or her decision within 14 days of that date. So that's, I would say, that's pretty quick. Another tool, after the constitution of the tribunal, the applicant can apply to the tribunal for an intermeasure order. There is no specific timeline embedded in the rules by which the tribunal has to issue its decision. We had one case in which the applicant asked the tribunal to order an injunctive, to issue an injunctive order, ordering respondent to refrain from some court actions in the United States. The tribunal took approximately, I think, 50 days to deal with that request. And the order for intermeasure came also in the form of a final award. So basically, respondent was ordered to refrain from pursuing further litigation in the United States. There's another tool, which is the Hong Kong and PRC intermeasure arrangement. I'm sure our audience today have all heard about this arrangement. So parties to arbitration seated in Hong Kong and administered by HKIAC can apply for asset or conduct or evidence preservation to PRC courts. Of course, the parties can also apply to Hong Kong courts and in other jurisdictions, but this arrangement is sort of Hong Kong's advantage. To date, we haven't seen any applications in IP cases like taking advantage of this tool. However, we HKIAC are aware that in mainland China, parties to arbitrations have been seeking court orders in respect of either conduct or evidence preservation in IP disputes. And in fact, in 2019, the Hainan No. 1 Intermediate People's Court has indeed ordered to preserve respondents' conduct, requested respondent to refrain from using certain equipment of the applicants in that order. So we do expect to see some parties taking advantage or using this tool in the near future. That's all for me. Thank you.
Do we have any questions from the physical attendees?
I've got one comment.
Could I ask you to come up to the podium? So a question, a comment from Doug Clark.
Yeah, sorry, I was just interested very much in the discussion about getting an agreement to arbitrate for disputes of reason, and we've all tried.
Is your mic on?
We've all tried many, many times to do that and failed many, many times. I think the only time I've heard of it succeeding, it wasn't my case, was in the US when I went to some presentations by US lawyers, and they said how they got an agreement from a defendant to arbitrate was their original claim in court was $2 billion. And they went along and said, we'll cap our claim for damages to $600 million, meaning that if you arbitrate, you will not pay any more than that, no matter what the arbitrator awards. And that worked. In fact, the lawyer said, we're not interested. But it got to the CFO who said, I am totally interested. I take $1.3 billion or $1.4 billion out of my accounts as a contingent liability. We're going to arbitration. So that's the only time I've ever heard of it actually happening. So I just want to make that comment.
That's a good point. And because with an arbitration agreement, you can really define what the issues are that are going to be argued about. You can set, I've seen caps and floors so you set the parameters of what the award is going to be. Also, things like each party will have no more than 3 days to argue, and a really strict timeline, and all of that can be attractive.
Yes.
But if you've got deep pockets and just want to be bloody-minded, then the defendant will not agree to any of that.
Mm. Or you try and bankrupt the other side, as you've done a few times, Matthew.
Well, I think the parties have to be given some incentive in arbitrating, and for those who don't understand the procedure, there may be some education that is needed.
Well, we have a few minutes left. Perhaps the panel will endeavour to type some answers to some of the questions that have come in online that we haven't been able to address. And perhaps I can finish with one question for the panel. And I'll begin by saying it's quite interesting to see the statistics from the HKIAC, to see that arbitrations to do with software and pharmaceutical and telco issues have increased markedly in recent years. That seems to be perhaps a future trend. My question for the panel is, what other future trends perhaps do you see in the field of arbitration of IP disputes?
Well, in my area that I've been speaking about a lot, potentially this could be a tool, an attractive tool here. At the moment, at the receiving end of a lot of this litigation is Chinese parties. And if it can be established that HKIAC has a leading panel of arbitrators who can handle this sort of complex dispute, that may well be quite attractive to some Chinese companies. So that's an area that I think may grow in the future.
Yes. I'm able to observe that there is indeed a very marked growth of arbitrations involving Chinese parties, involving significant IP issues. Now, this arises from the maturity of the manufacturing industry in China. So after they have learned how to make things or how to devise new things on top of the things that they have been taught how to make in technology transfer arrangements or in manufacturing contracts, they are never satisfied with just the same kind of manufacturing arrangement whereby they are just a factory and they're given the design and they make it for the client and ship it off. They're never really just satisfied with that. So they will venture to learn the skills and then try to invent or devise their own designs. Now, a lot of disputes arise from that because it is a cash cow for the foreign party having things manufactured in China. They have a huge profit margin. But when that stops, when then they can no longer rely on this manufacturer, but instead this manufacturer is actually competing with it, most of them cannot swallow it. And litigation is very often commenced because of that. And in this kind of litigation, one has to resolve disputes as to whether there was a kind of misappropriation of the technology or misappropriation of information. So a lot of breach of confidence cases. And then whether there was misappropriation of drawings and whether actually the defendant or the respondent's new devices or new invention were actually their own design independently from the claimant, or whether it was taken from a third party not related to the claimant. So these are the type of disputes which I see as rising in number.
Well, it remains for me to thank all of the attendees online and in person, and to thank the young members group of the East Asia branch of the Chartered Institute of Arbitrators, I hope I got that right, Ronald, for proposing this seminar, and for the HKIAC for jointly hosting and providing venue, and of course this excellent IT support. And finally, many thanks to the panel for participating today.
Thank you.
Thank you.
Thank you.